Welcome back to Conozca sus Derechos, Know Your Rights. Programming brought to you by the Hispanic Bar Association of Central Florida. I am Henry Lim, Community Relations Chair of the Hispanic Bar Association of Central Florida. We're continuing our discussion on family legal matters with attorneys Maribeth Gonzalez and Gisela Den Laurent. One of the topics that we see a lot is domestic violence. What is the first thing someone should do if they feel they are victims of domestic violence?
Well, Henry, I think the first thing that they really need to do is contact law enforcement so it's documented. Even if the police show up and just keep the peace and have one person leave the home, at least it's documented so that if there's a history of violence, you have that documentation.
And is there a difference when it comes to domestic violence between a civil matter and a criminal matter?
Yes, usually domestic violence can go along with a battery charge. So, for example, for a battery for a battery charge in the criminal court, there's a higher burden to prove. It's beyond to exclusion of every reasonable doubt. So you might lose on a criminal case, but you might win on a civil case because it's a lower standard. And also, who is the client? And so in the criminal matter, the state is against the person that committed the crime. In a civil matter, it's the victim. It's the victim that gets to speak out. So, for example, in a civil matter, it's the victim that is the case. In a criminal matter, even if the victim doesn't want to testify, and this is usually what's confusing because they'll say, I don't want to move forward with the case, the state can still proceed in a criminal matter. And also, if the person that's being accused, if you did it, you might not want to say anything in a civil matter because whatever happens in the civil matter and a domestic violence injunction can be used against you in the criminal law matter, which makes it a lot more easier and faster to prosecute you in.
Well, let's talk about something that you just mentioned. You mentioned that even if the alleged victim does not want to pursue criminal charges against the perpetrator, the state can still charge the abuser.
Yes.
We see a lot of programs on TV. We see that, oh, you want to file charges, and when they say no, that's it, they're done. So how does that work?
Well, they'll still need to prove their case. The state has to meet its burden. So if the victim is uncooperative, they're not going to be able to meet their burden. However, the state attorney's office has a victim advocate that will talk to them. Maybe the victim is scared and says they don't want to prosecute, and they really do, because maybe they have lack of resources or don't know about Harbor House. So even if they say they don't want to prosecute, the state will still move forward. Technically, they can sanction you, but they're not going to do that.
They don't try to re-victimize the victim. But as Maribeth was saying, they can still go forward. And what happens is that domestic violence doesn't always happen in a bubble. So they can have independent witnesses. If this happened in a parking lot or an apartment complex and they have independent witnesses, they will go forward. And if there's a history of domestic violence, there was children involved, they'll have other motivating factors to take the case forward without the victim's cooperation.
So let's say that someone calls the police and it's the fifth time that the police has been called to the house. Those other times can be used against the alleged abuser?
They won't be used against the alleged abuser. However, it will be more motivation for the state to go forward on the case because you can't use prior bad acts against a person in the current charge.
And we're talking if the alleged victim does not want to proceed charges, even though she's called the cops 5 times.
Exactly. She has called the law enforcement 5 times. The state finds out about that, they're going to say there's more to the story, and they'll be more motivated to go forward.
I see.
But actually, and just because that actually happens more than not, and sometimes the reasonable person looks unreasonable. So there's cases where the victim calls multiple times and then drops the charges, and then it's like crying wolf. They don't believe you. Even though it's happening, they might not take the victim serious because she keeps dropping the charges. So that's a little difficult situation to deal with.
Okay, I see. Well, we've discussed civil and criminal, but perhaps we should clarify a little bit. Criminal is when the state is pursuing criminal charges against an alleged abuser, correct?
Yes.
And civilly, what does it mean when you're talking about civil relief available to an alleged victim? What can a victim do with using the courts on a civil side?
Well, on the civil side, the victim can ask for a petition for a domestic violence injunction. What that does is that takes some measures. For example, the batterer might be told to stay away from the victim 500 feet within the house. Also, to any places that she visits currently, I'm sorry. Also, the injunction will put in order child support, time sharing for that period of time. However, if those issues are so severe and there's a marriage, you should also seek a divorce because the injunction ends at some time if it's not permanent. So it's not forever. Sometimes they're granted for 3 months, 6 months, a year. So you got to be careful with regards to that.
Can an injunction ever become permanent?
Definitely.
And what does it mean when we say permanent? Does that mean forever, that the person cannot contact this individual?
Yes. Like Maribeth said, initially an injunction, well, first of all, when you apply for an injunction, if there's grounds, the court will give you a temporary injunction and have a return date so that the other party can defend themselves against this injunction. At that hearing, the return hearing, the court can decide whether they're going to give it for a month, 2 months, or indefinite, which is permanent. The reason for an expiration date is if there's something going on within the relationship, for example, the parties are about to go through divorce, the court may find that because of this divorce, this aggravating factor, they just need a Band-Aid to get through this process, and then the hope is that they'll have a transition period and they'll move on with their life. The injunction, if you don't come back within the time that it's actually open, it will just automatically close, okay?
Now, what does one have to do in order to have an injunction approved? What do you have to prove? What's the standard of proof for the alleged victim to have an injunction approved by the judges?
It's the standard is imminent fear of harm. So,
and how is that defined?
Well, if the party has a reasonable fear that they are in danger by the other person, first of all, they have to be domestic, so because there's a repeat violence is a non-domestic. But if it's domestic, so you guys are related by blood or marriage, or you've lived together, and then you're in imminent fear of harm, that means you reasonably believe that this person will harm you. That's it. It's a much lower standard to prove. If the court believes that you're in fear, they will grant your injunction.
And the biggest mistake that people do with regards to imminent fear, because there is no straight answer. So, for example, if something happened 2 weeks ago, and now you're going to seek an injunction about something that happened 2 weeks ago, that's not imminent fear.
I see. Okay. Well, let me give you an example. Let's say that my ex-wife files an injunction against me, okay? Or my wife, we haven't gone through proceedings, files an injunction against me. The judge grants the injunction against me, okay? And she calls me, and she tells me, "Hey, come on over. Let's get together for lunch." And I show up, and for lunch, can I be arrested? Am I in trouble?
Yes, it could be a first-degree misdemeanor, a violation of injunction. You can be charged with that. But yes, because there's no injunction against her. There's no order restricting her, telling her what to do. The person that has the order is you. So you are disobeying an order from the court.
Do I have any defenses?
Absolutely not. It might be mitigation because the court ultimately has the discretion to what his sentence is going to be for your contempt. And you can say, listen, she contacted me, she said that she had talked about the children, I met up with her, and she called the cops. But ultimately, you have to tell people all the time, you are the only one that's bound by this order if the injunction is against you.
Does injunction have anything to do, or does it affect child support? Does it affect alimony? How does an injunction come into play with those issues in a divorce setting? Because we're talking about two separate things, right? Mm-hmm. An injunction for domestic violence is different from a divorce setting. So how does someone who has been granted a temporary injunction, how can that be used in a divorce setting? Or can it?
Well, it can be used different ways. First of all, in a domestic violence injunction, they can put temporary child support, alimony, settle issues with regards to time sharing, and things such as that nature. However, the divorce case will trump those issues if those issues are addressed with regards to the divorce.
Okay.
And also, Henry, at least every county is different, but what I've seen mostly in Orange County is that if the courts know you have a pending dissolution of marriage, they try to not weave them together. They will say, I'm going to issue the order for injunction, and I'm going to let the dissolution judge or court handle those issues. It makes it cleaner that way, so you don't have competing orders.
And what can I do if I have an injunction against someone and they violate it? What should I do? If they came to visit me and I tell them, no, you have to go away, what rights do I have for someone who has violated the injunction?
You call law enforcement right away. And injunctions are a piece of paper. So you've heard horror stories, especially within this year or last year within Orange County and in Seminole. The injunction does help because you can call law enforcement, and the person violates, they can be charged with criminal charges. But at the end of the day, it's very important for a victim to have a safety plan, to have a plan for where they're faced with that situation and they can't think. It should be second nature. This is what I'm going to do without thinking because this is what's happening. Because when you get caught off guard, it might be very dangerous, and the police are not right there. Right. At every moment of your life.
Right. It's very important to know your rights. Unfortunately, our time is up. We thank you for tuning in. I want to thank Maribel Gonzalez and Gisela Den Laurent for their participation in Conozca sus Derechos. The Hispanic Bar Association of Central Florida is dedicated to community service, and in our upcoming episodes, we will continue to discuss family legal matters and other issues important to the community at large. We wish to thank Orange TV for their assistance in bringing you this program. For further information, please visit hbacf.com. Thanks for watching. We'll see you next time on Conozca sus Derechos.